So hello everyone and welcome to Career Launcher. So in today's class, we are going to discuss 138 Constitutional Amendment Bill. So I hope you are aware if you are reading newspaper, it was very much in the news when it was presented in the Lok Sabha. The opposition actually protested also. So things related with that was in the news, and that is why I have decided to discuss this bill in detail. So this is 130th Amendment Bill. I'm sure you must be aware that this was in the news. Marshals deployed, torn copies flung, and MPs, that is Member of Parliament, come to near blows as 138th Amendment Bill introduced in Lok Sabha. Okay, so we'll discuss this in detail, what exactly it is and why the opposition was protesting against this bill. So let us start. So basically, first of all, there's a question for me. How many constitutional amendments have been done so far? Your options are 99, 105, 103, or 106. So if you know the answer, you should write it in the live chat. Or you can write it in the, if you are watching a recorded video, write in the comments so that like it will be a good revision for you. So basically, you have to understand one thing, that till now we have seen 106 amendments. You can see. Now, so we have seen 100 up to 106 constitutional amendments have been done. Now you're saying, sir, here it is written 138 Amendment Bill. How it is possible? Because you have to understand that bill is a proposal for becoming an act. If it is passed by Lok Sabha, Raj Sabha, and approved by the President of India, then only it becomes an act. Okay. So here it means we are having 106 constitutional amendment has been done, but you have to understand one thing, that it was not 106 constitutional amendment bill, because many bills have not become an act, many of them. Okay, this you have to understand it. So currently we are having 106th amendment was done, and the most latest one was actually 106th Amendment Act that was passed by both the houses and approved by the or given assent by the President of India. And this, the last one, that is the 106th Amendment Act, was 128th Amendment Bill. This was 128th Bill, and it was passed. It became 106th Amendment Act. Means it has been passed by both the houses and approved by the President of India. That is what you should be knowing about. So what was the 106th Amendment Act? So it seeks to provide 33% reservation to people elected for Lok Sabha, State Legislative Assembly, and Delhi Legislative Assembly. 33% to women, actually. Yes, that's the idea. That 33% reservation for women would be reserved for Lok Sabha, for State Legislative Assembly, and for the Delhi Legislative Assembly. However, there is a provision that it can be implemented only after the next census would be done. So next census and next delimitation commission is set up. So most likely 2026 or 27 will be having next census, and after that there will be a delimitation commission would be set up, and after that it would be implemented. What we call it as Nari Shakti Vandanam Adhiniyam, or 186 Constitutional Amendment Act. Okay, this is what you should be knowing. So I'm giving a basic idea about constitutional amendments, bills, acts, etc. That is what you should be knowing about. Okay, and before that, if you see, right now, so we have seen it that 128th Amendment Bill was related with 33% women's reservation in Lok Sabha and Legislative Assembly, and this became 106th Amendment Act. Now, what is 129th Amendment Bill? Because 130th Amendment Bill we are going to discuss today. This is the discussion of today. But let's talk something about 128th Amendment Bill, and it has also not become an act. So this is about what? You have to tell me. It is also yet to become an act. The matter is still pending. And the answer to this question is one nation, one election. Okay, A is the right answer to this question. Also known as simultaneous elections. And please tell me a name of the name of the committee that was set up in this regarding simultaneous election. So the name of the committee was Mr. Ramnath Kovind Committee. So Mr. Ramnath Kovind is the former President of India. And under which a committee was set up to recommend things or points regarding one nation, one election or simultaneous elections. Okay. Now, what is one nation, one election? I hope you are aware, but let me tell you. This means that in one go, all the so the Lok Sabha elections, which actually happened last year, right? Similar to that. So Lok Sabha elections and all states legislative assembly elections should happen at one go. Should happen at one time. So there are a lot of positives and negatives regarding it. But the most important thing that you should be knowing is that actually the idea behind simultaneous election is that in one go, there should be Lok Sabha election in entire India, and at the same time, all the state legislative assembly election is done. Now, how? Because of course there will be an EVM. Let's say everything will be done so that you go inside the voting room and there will be two EVMs. One will be for Lok Sabha elections, and the other will be for legislative assembly elections. Okay, that is what you should be knowing. So the bill amends the constitution to conduct election for Lok Sabha and all state legislative assembly together. That is what the bill is. And the bill actually has been sent to JPC. So still it is a bill and it has not become an act. So this we are talking about is 129th Amendment Bill. It is yet to become an act. So we are saying it as a bill. So now this is about 96th Amendment Act, which we have done about women's reservation 33%. Then this is 105th Amendment Act regarding OBCs, etc. We are not going in that detail. Then 104th Amendment Act was there. Then 103rd was related with providing 10% EWS reservation in unreserved category or general category. We have now 10% reservation for EWS. Similarly, 102nd Amendment for National Commission for Backward Class. 101st Amendment for GST, that is Goods and Services Tax. Okay, that is what you should know. Then 100th Amendment Bill was related with there was a land boundary agreement with Bangladesh. And this is very important. 99th Amendment Bill is related with National Judicial Appointment Commission. This was related with appointment of judges in High Courts and Supreme Court. Okay. However, the matter was struck down by the Supreme Court, and today we are having still a collegium system is there for appointment of High Court and Supreme Court judges. If you are interested in knowing it, you can watch this class. You just search this on YouTube. Just go on YouTube and search Collegium Career Launcher. You will get this video. Okay. So you will get this video. Why this video? Because this will explain in detail about how the appointment of judges happen in High Courts and Supreme Courts. If you are interested, you can watch that. Now, let's talk about today's topic, that is 138 Constitutional Amendment Bill. Why it was in the news. That is very, very important. Okay. So basically, this is actually the statement that is given. A minister who, this is about the main crux of 138th Constitutional Amendment Bill. So it is Constitutional Amendment Bill. So a minister who for any period of 30 consecutive days during holding the office as such is arrested and detained in custody on allegation of committing an offense. Allegation of committing an offense under any law for the time being enforced, which is punishable with imprisonment, which may extend up to 5 years, shall be removed from his office by the president on the advice of chief minister to be tendered by the 31st day. Okay, I'll tell you. What does it mean? It means, for example, if there is a minister, the minister can be at state level or at the central level. Both. So state level minister means a chief minister or any other minister. Similarly, at central level, a minister means prime minister or any other minister. So it includes prime minister also. So this is the idea behind minister, which is mentioned in the bill. Okay. So a minister who is arrested, let's say, for example, a minister has been arrested by any agency, let's say ED, CBI, or any other agency, and the matter is still pending. So it means the matter is under trial, it has been arrested, and the person has not got bail for 30 days. So on 31st day, this person will be removed as the minister. This minister means a chief minister of a state, any other minister of a state, or at the union level, a prime minister or any other minister. That is what you should be knowing about. Okay? I hope it is very much crystal clear. So basically, now what is the that is what you should be knowing. So basically, it says a bill says that any minister, it can be a state minister or a central minister, it can be a prime minister or a chief minister also, who has been in jail for 30 days for a serious offense will lose the seat. Yes, the thing is, a person should be arrested for a crime which gives punishment for 5 or more years if that person is proven guilty. But what is problematic? Problematic is that only allegation is made and the person has been arrested by any agency. The minister has been arrested, but still the matter is under trial. Okay. So a minister, let's say chief minister of a state, has been arrested by an agency, ED, CBI, or any other agency, and the person has not, that chief minister has not got the bail for 30 days. So on the 31st day, he will lose the seat. He will no more be the, he or she will no more be the chief minister. Okay, that is what you should be knowing it. So that is what the idea is. Now, so basically the thing is, we'll discuss it, what we call it as presumption of innocence. But first answer this question, then I'll explain in further detail. The 138th constitutional amendment amends which article of the constitution? Article 75, 191, 211, 368. What is the right answer? Actually, it amends Article 75, 164, and 239 AA. 75 for central level ministry, 164 for state level, 239 AA for Delhi Legislative Assembly. So A is the right answer to this question. Okay. Yes, so 31st day, the chief minister or the minister will be removed. So Article 75 is there. Yes, you can see a minister will be removed. That is, I'm showing from the official website. From the office, if he is accused of a punishable offense with a jail term of 5 years or more, means minimum the crime that he or she, the accused, has committed, if he or she is found guilty in the court, then the punishment would be minimum 5 years. Then only this law will uphold. I mean, this law will come into force. Okay. So this is for the crime for more than 5 years, right? And the person has been arrested and detained in custody for more than 30 consecutive days. So the 31st day, that minister, the ministership will go. He or she will no more be the minister. Okay. Inside the jail, now from the inside the jail, he or she cannot be the minister after 30 days. If within 30 days, if the court has granted bail, fine, then of course he or she can come back and be the minister. But if the court has not granted bail for 30 days, then of course he or she will lose the chief ministership or ministership. Okay. Now why? Because I'm sure you must be aware, last year Mr. Arvind Kejriwal was arrested and he was in jail for more than 30 days. But still he was the chief minister. He said, I will not resign. I will work as a chief minister of Delhi from the jail. And at that time, actually, there was no provision to remove the person because he was an under trial and not a convict. What is the meaning of convict? Convict means proven guilty in the court. He is found guilty of corrupt practices or anything else. Under trial means there is an allegation against the person, but the matter is sub judice. It is pending in the court. Okay, that's what you should know. Mr. Hemant Soren refused to sign arrest. Now, but what similarly, there was a Jharkhand chief minister who was also arrested, but he actually resigned from being a CM before getting arrested. Okay, but in this case, Mr. Arvind Kejriwal's case, he did not resign. He said, I will work as a chief minister even from the jail because there was no provision to remove an under trial. There is a provision for convicted. If a person is found guilty in the court, that's mentioned in Representation of People's Act. We'll discuss it. Okay, that is what you should be knowing about. So here it is. So we are done with this. Yes. Now, one more thing. If after, let's say, a person is arrested, let's say a person is a chief minister, the person is arrested by any big agency, he is sent to jail, and he has not got bail for 30 days. So on 31st day, his chief ministership would be gone. Now let's say, and some other person from his own political party becomes the CM. Now let's say after 10 days, let's say on the 48th day, this person has got the bail. Okay. Now he can again come back and become the CM by telling the newly appointed to resign, and he can again come back and become the CM. Okay. So theoretically, there is a provision that if a person has got the bail and he has come out of the prison, then still he can become the chief minister or the minister, even if the matter is pending in the court, because he is an under trial, right? And the matter is still pending. But since he has got the bail, now he or she can again become the CM or minister, or whatever is the case. So this is 138 Constitutional Amendment Bill. Okay, its amendments talks about Article 75, talking about union minister. So basically, this is Article 75, talks about union ministers. So 75, 5A. So here is 5A is here somewhere. So here the provision has been added regarding that 30 days law. Okay. Similarly, Article 164 is related with state chief ministers and other ministers, right? So 164 4A, 164 4A. So 4 after that, here after clause 4, 4A has been added to provide for that 30 days law. And we have discussed what is 30 day. On the 31st day, the chief minister has to resign. If the chief minister or a minister has been arrested and has not got a bail for more than 30 days. Similarly, Article 239, capital A. Okay. Now, again, the same thing, and 239 capital A is actually related with Delhi. Okay. That is what you should be knowing. Again, the same thing. Now, what are the issues raised with the bill? So we'll discuss both aspects. So there are two aspects. The first aspect is what we call it as presumption of innocence. So it means a person is which says, this is a very famous rule in the criminal justice system, which believes that a person is assumed to be innocent until proven guilty in the court of law. So by default, you have to assume person to be innocent until the person is proven guilty, means convicted in the court. Okay. So basically, first imagine yourself, like for example, if there is a minister or a chief minister who is arrested by a big agency, and this chief minister could not get a bail for 30 days. So on 31st day, his chief ministership would be gone. The matter is still pending. It is an under trial. And if the chief ministership is gone, then technically it can be considered as a sort of a punishment. So that is one thing, that, okay, you have punished the person by removing him from the office, and the matter is still under trial. So that is one thing which has been raised or criticized in this bill. That's called as presumption of innocence. The other aspect is the problem with the judiciary is the criminal justice system is very slow. So for example, let's say there is a person who is actually an MLA, and the person commits a crime. Let's say he has committed a murder. I'm just giving an example. Now, the case goes for 10, 15, even 20 years. Now, in these 10, 15, 20 years, this MLA becomes very powerful. He or she becomes a minister or a CM or let's say a union minister or something like that. Now, after 20 years, if the case comes in front of a judge, it is very difficult to punish. Why? Because he has become powerful. Nobody will give an eyewitness against the minister. Okay. And nobody will actually, let's say, give any proof against the minister because he has become very powerful. So what was the reason? If you give the logic, if the MLA would have been disqualified here, then there was less chances of becoming a minister or something like that. So these are actually the two aspects of it, that what we call it as criminalization of politics. And actually the main reason for criminalization of politics is this: slow criminal justice system, very slow judicial process. Okay, so this is actually also becoming problematic, that if we want to clean the political system, then of course we need to have a fast criminal justice system, so as to ensure that those who are having criminal background should not come into politics, rather than clean people should come. That is also the idea behind this. Now, the current provision regarding disqualification of member of parliament or minister is mentioned where? If the person is convicted. Now here I am asking question, convicted means he has been proven guilty. I am not saying that he is actually there's an under trial. Here now we are talking about convicted person, this question. So earlier, 138 Amendment Bill was talking about the person who is an accused and arrested. It was not talking about the person convicted, which we had done till now. So here actually Section 8 of Representation of People's Act, right? 1951 talks about it in detail, about if a person is found guilty, found convicted, then of course he or she will be removed. So what is the case? If you read it about Article 102 of Indian Constitution, it says, and one of the reasons you can be disqualified as a member of parliament is if any law is made by the parliament. And mentions provision regarding it. So of course RPA is there, Representation of People's Act 1951. Similarly, 191, disqualification of MLAs and MLC. Disqualified under any law made by the parliament. Okay. Now, so for example, let me show what exactly is the law. So this is the law, Section 8 of Representation of People Act. Clause 1 says, a person convicted means proven guilty in the court under these law. You can read it. For example, dowry offense, crime related with against women, promoting enmity, and these other civil rights violation, custom acts. If you are found guilty of UAPA, NDPS, FEMA, okay, these are the provisions that you know. Sati, Prevention of Corruption Act. So, and POTA. So these are the provisions. If you are found guilty, of course, you will be disqualified. Plus, in general, this is the rule. If a person is found guilty, if a person has been convicted by even by a lower court, high court or Supreme Court, any court, and the punishment and the jail term is minimum 2 years, greater than or equal to 2 years, then in that case, that person, if he or she is an MLA, he or she will be disqualified. He will go to the jail, and after the jail, he or she comes out. Even for the next 6 years, after coming out from the jail, he or she cannot become the chief minister or minister. Okay. So someone is arrested, sent to jail. Let's say a person is jailed for 2 years. After he comes out from the jail, for the next 6 years, he or she cannot become an MP or MLA. Okay. So let's say on this day in 2025, a person was MP or MLA. He was found guilty in any law, and the jail term is more than 2 years. So he will go to the jail, and after 2 years, even if he or she come out of the jail, still he cannot fight the election. He has to wait for 6 more years. Okay, that is the law. However, of course, that is what the so something similar happened with Mr. Rahul Gandhi, where 2 years back the Surat court actually found him guilty in a criminal defamation case, and he was sentenced to 2 years jail. So in criminal defamation case, maximum punishment is 2 years, and in Representation of People's Act Section 8 Clause 3, you need to have a minimum 2 years jail to be disqualified. So the Surat court found him guilty, and he was actually disqualified. However, the matter was appealed into the High Court and then the Supreme Court. So in the Supreme Court, Mr. Rahul Gandhi got his sentence suspended. And that is why his member of parliament, his MPship was restored back. Okay. That is what you should be knowing about. Okay. Yes. Anna. Now we are not going in that Lily Thomas case because that's not important, but I think we have done whatever you are supposed to know, right? So 138 Amendment Bill, yes, we have done it. The main problem is actually the person is actually detained or arrested, but it is not proven guilty. And the main problem why the opposition has raised this is it's only a person has been arrested and not convicted. The matter is still pending. And if you are in the jail, if a minister is there, if a minister has been arrested for 30 days, and on the 31st day, you will be disqualified from being a minister or chief minister, even if you have not got the bail, and even if the matter is pending. Okay, so that is why people were protesting, etc., the opposition parties. Okay, now the bill has been sent to Joint Parliamentary Committee, which comprises of members from Lok Sabha as well as Raj Sabha. It has 31 members. So generally, it is like this. Joint Parliamentary Committee, so let's say there are 20 members from Lok Sabha, so in Raj Sabha there will be 10 members. Generally, it's double. Okay, like that. So there are roughly around 31 members in this JPC, Joint Parliamentary Committee. Okay, which will find out and research about that. Okay. So, I mean, the Joint Parliamentary Committee, there'll be discussion that happens among the members, and they discuss and give advices, etc., like that. So, in the past also, we have seen before scandal, Harshad Mehta scam, in many other scam, the matter was sent to JPC. Okay, then VVIP's chopper scam, language acquisition, personal data protection bill, even Waqf bill was also sent to JPC. Then we have One Nation, One Election bill. It is also being sent to JPC. It is 129th Amendment bill. We have discussed this also. Yes. So even in the past also, what Supreme Court had said, so Supreme Court, there were petitions were filed that, of course, the politicians, regarding punishment of politicians who are found guilty. But the thing is, who are yet to be found guilty, I mean, if there is a serious charges, means there is a serious allegation, but it is not proven guilty. For example, if you see this, in the recent Lok Sabha election, which happened last year, 46% of the newly elected Lok Sabha MPs have criminal cases, but they are under trial again. They are yet to be proven guilty. Now the problem is the matter is pending for, let's say, 15-20 years, and many of them have allegations of actually big allegations, etc. Okay, so of course in that case we have to actually, there should be some provision of removing those people who are even found guilty, or who are even yet to be found guilty, but there are serious charges. Okay, so there have been a lot of petitions in the Supreme Court that allow those candidates should be barred if there is a serious criminal charges against the politician, even before being proven guilty, right? So the idea is, even if they are under trials, but the charges are very serious, then those people should not be allowed to fight election. So for that, petitions were filed in the Supreme Court, but the Supreme Court has said, look, this is the job of Parliament to bring the law, not the judiciary. Okay, so judiciary cannot legislate, and it is the job of the Parliament to come up with those bills. That is what the Supreme Court has said. Okay, and yes, the main problem actually lies here. All the things we are discussing, the main problem lies here. We have almost 40% High Court vacancies are there. A lot of vacancies are there in the lower judiciary also. That needs to be filled, so that the slow and tardy criminal justice system should become very fast. Okay, you can see so many cases are pending in the courts. That is, of course, serious things. So this is all about today's class. Just read something about him. So this was in the news recently. This is just an additional information you can get. So this is all about today's class. Please subscribe to the channel, press the like button, share this video. Thank you, everyone. Thanks for watching.